it was. Good morning, you're Norberto Armenta, and this is cause number 25 DCCR 0168. Mr. Armenta was previously in court, entered a plea of guilty to driving while intoxicated, third or more, in addition to pleading true to prior offenses, making this a second-degree felony offense for punishment purposes. And there was an agreement of a cap of 12 years and to dismiss the evading as part of that plea agreement. I've received the pre-sentence report as well as a whole packet that the defense provided that has certificates and different things that I have reviewed. Has everyone had an opportunity to review the pre-sentence report as well as those other documents?
Yes, Your Honor.
I have.
Are there any additions or corrections?
No, ma'am. No, ma'am. No, Your Honor.
All right, Mr. Kimler, you may proceed.
Well, Your Honor, we start as usual with the criminal history, which is rather extensive, Mr. Armenta. I will say I've spoken to him at the jail extensively and reviewed the case. And this is really an unusual fact situation in that he's the one that called 911 on himself in the vehicle because he was having what I thought, and I'll let him explain it to you what the reasons that he did call and concerns. And as a result of that, received the DWI. The evading detention, Mr. Armenta, is from Harris County and has had some bad experiences with law enforcement. I think there was a low speed failure to stop. They did deploy the spike strip, and he ultimately came to a stop. But he related to me that he was in fear, I guess, of law enforcement and wanted to get to a spot where he would feel safe pulling over, and that's what he did. But I'll let him elaborate as to his thinking on that.
Well, but what you're thinking is on that really isn't going to matter. You were on cocaine and Xanax at a minimum that day, so your thinking was not clear because you were under the influence of a lot of things in driving.
That's
so
correct,
okay.
Your Honor. And I think that he relapsed, I would say, because he has indicated, and I guess enough factually demonstrated that he is trying to maintain a sobriety through our religious faith-based rehab, or I'll say programming, but efforts to maintain his sobriety. And the certificates that have been provided to the court were obtained by him while he was in custody in Harris County Jail, awaiting transfer over here. He does have a motion to revoke probation in Harris County for a DWI that will be resolved after this case is disposed of. In the VSI, again, relating to criminal history, there's some self-reporting that Mr. Armenta did as far as gang affiliations. I want the court to know too that these are self-reported by Mr. Armenta. He didn't have to inform the probation officer. These are things that he told the probation officer in good faith about his history because he wanted to be honest about things. It certainly doesn't make him look good or any better, but it was important to him that he be honest about that. We're not asking for probation on this. It's a 12-year cap, and I think Mr. Armenta really is in a better position than I am to give the court an indication of where he is in his life as far as his recovery, what his plans are, what his efforts have been. So I would defer to him at this point, talk to the judge and let her know where you are.
Did she get my college papers?
Yes, and he also, yes, there's some paperwork. He was in San Jacinto College, I think.
Right.
Yes, ma'am. Good morning. My whole life, I've been a criminal all my whole life. 2015, I began to change my life. I gave myself to God, and there's not much I can say, but I never, ever since I started doing recovery and trying to change my life, I had difficulties, and I was doing good and I relapsed. And Your Honor, I never dialed 911. And what they're teaching us is to take responsibility for your actions. And and that's one thing that I wanted to do is I wanted help, and I wanted to get locked up for a while. And take classes, and that's what I've done before, and that's the only way I knew how to get help. And you know, I apologize to the courtroom for my mistakes that I've made, but I've never called 911 on myself, and I feel like that's a big step as well. As doesn't make it any better, but I wasn't asking for probation, 2 years, 3 years, 4 years. I asked for 5 because I felt like, you know, I don't know if that was a good punishment for me, but I felt like I needed to get away for a while from wrongs that I did, for my mistakes, and I'll take full responsibility for my actions. And I'm sorry for what I caused. But I do have a daughter, and she's asking for me, and I'm just trying to better myself for her. And I never thought that changing my life would have to deal with me being an addict, and that's what I'm dealing with now.
Thank you.
Sorry.
Thank you. Ms. Malfino?
Judge, obviously, his criminal history dictates that somewhere in the range of 10 to 12 years would be appropriate for him and would have been a sentence that was mitigated by the cap. I do appreciate his honesty. It's not what we typically hear from a defendant. Usually it's the excuses. I appreciate that he's not even asking for probation and insulting the court that way, so I'll defer to what he thinks is best.
So, Mr. Armenta, I make notes and go through the pre-sentence reports. Obviously, before court, I use a highlighter to highlight convictions and things, and usually the prettier it looks, the worse it is. With highlighting, yours does not look good. Your criminal history, like you said, is ridiculous. I appreciate what you're trying to do now. Obviously, it's a little late or a lot late, but it's Ms. Malfino's right. People don't take responsibility. I had a note on here for pretty much what she said, that 10 to 12 was probably the right thing to do. I think I'm inclined to give something for what you are trying to do, but 5 years is not going to be it. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time, find you guilty of driving while intoxicated, third or more. Find those prior offense true. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, sir. Hopefully you'll continue doing what you have been. Ms. Holmes on Claudia Villalobos.
Received it,
You
at least
did?
by this morning, Your Honor.
Okay.
I'm not opposed.
Hold on a second. Good morning, you're Traylon Hill. Let's see, what is it?
It's a motion for continuance, filed by Mr. Batisky, Your Honor.
You just paid the bond before.
Nobody's talking to you right now, okay? Don't say, Mr. Hill, don't say a word unless someone asks you a question, okay? I don't see the motion, is what I'm looking for. It may be one of the,
Cases that ordered.
all four. I just got a script error. Do I hit yes or no?
Yes, it's fine.
All right, now my computer's acting up.
Did you try to run it? John, did you try to run it?
Huh? I haven't seen it yet. It's not even showing up, but now I've gotten to where I can't X out of anything, so. All right, so Mr. Hill's cases are set for trial to begin with jury selection next week. And Mr. Matuska, you filed a motion for continuance.
I did, Your Honor. At the last setting, Your Honor, the court informed me that this case was urgent. We did receive all the discovery. I printed out all of the written reports and provided a notebook to the jail. I've gone down there with the laptop. The guards at the jail have informed me that Mr. Hill is refusing to come out and meet with me, to go over his discovery with me.
Okay.
And I have not had an opportunity to show him based
Don't
on.
talk, I'm gonna talk to you in a minute.
I'm just saying.
Don't talk over people.
I'm not talking over him, let him know.
You're talking over me right
I
now,
own
and you're
him.
talking over him.
I own him.
Mr. Matuska,
Based upon that information I'm receiving from the guards, I've also reached out to the family, Your Honor. They seem concerned for some other reasons
I haven't been out to the cell in over
that
like
the court may be
5
aware of.
weeks.
But I have made efforts to provide him the opportunity to see his discovery, but the jail is telling me he's refusing to do that.
all right, so I'm going to grant the motion for continuance. I am also going to go ahead and order an evaluation be done. Mr. Hill, it's very important if Mr. Matuska or any doctor or anyone comes out to visit you, that you visit with them. It's going to help move your case along, okay?
Cool.
So
I
it's,
paid for Burbank, I don't even know who this is.
so
Y'all
you,
gonna just do it.
Mr. Burbank has not been paid because he's not here to represent you. Mr. Matuska is your
You
lawyer.
can put up his file
I represent,
on TV.
I appointed Mr. Matuska, who is an excellent attorney, to represent you. Mr. Burbank got off of your case.
But the reason why is
listen.
because I've been to court 14 times and I'm looking to go because I have no evidence on me.
Listen,
during this whole entire
you
matter.
and me both are ready
So
for
y'all
you to
been
go.
invading my- y'all invaded
Both
my
of us
community.
are ready. Go back with the bailiff.
Y'all invaded my
Listen, if they
community.
come out to visit
All my
with you, you need to
constitutional
visit with
amendments
them.
y'all
Go back
been-
with the bailiff.
Hey, watch where you hold.
Unless there's some,
Because there's a state jail felony, but there's no cap or anything here, so it's just unagreed.
it's just, if it's unagreed, it's unagreed.
Even if the punishment is within the range of punishment, even if the sentence is within the range of punishment.
I mean, that's what we do on all of them. Unless there's some thing that is given in exchange, there's another case isn't gonna be filed, or, you know, just anything else, then it could be considered some type of an agreement.
Yeah.
All right, are you Vishal? And will your client waive the formal reading of the indictment?
He will, Judge.
Mr. Vishal, in cause number 25 DCCR 0507, you're charged with the state jail felony offense of criminally negligent homicide from December 31st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up,
You
please.
gotta speak up real loud.
Yes,
And are you pleading guilty because you actually did what they've charged you with?
yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz? Speak up.
Yes, ma'am.
I need to hear you and she needs to hear you, okay? So do you fully understand those documents that you signed?
Yes, ma'am.
And it's my understanding that you are leaving your punishment up to the court, up to me. I want to make sure you understand that you have an absolute right to have a jury come and determine 2 things. The first is to determine if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving your punishment up to me. And is that what you want to do?
Yes.
State tenders number 1.
We have no objection, Judge.
It's admitted. Is there any evidence that Mr. Vishal is not competent?
No, Judge.
Also, Mr. Vishal, do you understand that a plea of guilty or no contest, if you're not a U.S. citizen, may result in deportation, exclusion from admission to the country, or denial of naturalization under federal law? All right. Then I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent to understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Gertz. He will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Thank you.
Good morning. Are you Mark Anthony King?
Yes, ma'am.
And Mr. King is charged in cause numbers 25 DCCR 1063, 1064, and 1065 with aggravated sexual assault of a child in each of those cases. And what is the announcement?
Judge, it's really on me. I've been trying to get with the family of the victim and talk to them about a potential offer or anything in the case. I've not gotten returned to my calls,
Okay,
and so I'm gonna keep trying. I have not been able to get in touch with them the last few weeks. I've left messages on the numbers I have, and I just need to be able to get in contact with them, Your Honor.
all right, so I'm just gonna do one more reset.
I think that should
Obviously,
be fine,
if you need to do anything to get them here, get that done and taken care of, and then we'll get an announcement at that next court date.
Yes.
If there's still issues at that point, or at some point with you being unable to get them, if there's so request for a bond, then I would consider a bond reduction
Certainly,
as well,
I
if you wanna
understand.
get something filed.
Yes, ma'am.
Okay, you can go back with the bailiff.